welcome. Welcome very much to Promoting Collaborative State Administrative Office and Trial Court Relationships. Do you have what it takes? And today we have the dream team. Let me tell you why we have the dream team. All of these people are current or former state court administrators, right? So they kind of know from that end. All of them have been at trial court administrative levels as managers, so they've been like many of you. Two of them are former NACM presidents. You can do your little who is that, but you probably know. And two are current or former, this is our current, there is our former, state court administrators of the COSCA, presidents of the COSCA. I didn't say that. NACM presidents, COSCA presidents. I'll get it right here. All of the states that they represent, there are only 4, but they're all very different, very unique in terms of structure, organization, funding, governance, trial court administration, unification, roles and responsibilities of both trial court and state court administrators. So why is that important? Because none of you can sit there now and say, well, they don't know what it's like where I'm at, because we've covered the gamut. I'm going to let each of them introduce themselves a little bit so you know just a little bit about why we picked these people for our dream team.
We will go alphabetical, so I'm David Boyd. We're going to try and make this easy on you. Sometimes in COSCA now with David Slayton, I'm referred to as the elder David, and Slayton is the younger David. Yeah, well, it's amazing too. I've actually been in the field of court administration longer than the younger David has been alive, which is something of a scary thought, but it's not quite as scary as finding out after I walked in the room that Ernie Friesen would be sitting back there listening into this. I first met Ernie in 1976, give or take, something like that. So anyway, I've spent my entire career actually in the state of Iowa. Iowa has a unified trial court system. We now have, since 1983, we have a state-funded, or I call it a centrally funded court system. I use that term because we like to do things the Iowa way, and so we went to a state-funded system, but we have what we'd like to consider anyway to be a very decentralized administrative structure. Try to leave as much of the day-to-day operations at the trial court level with our district court administrators instead of from on high in my office. The interesting thing that's come about in recent years actually through that, though, is the fact that the trial courts are now asking that the state office become more directive and actually tell them specifically how to do certain things. Anyway, so that's basically my background and where we're coming from. Pam?
Good afternoon. My name is Pam Harris. I'm the state court administrator now in Maryland. And before that, I served as a trial court administrator in Maryland for, well, we'll just say like a long time. Like a long time. And then I moved over to what we call, or what I used to call, and my other administrators called, the dark side. And moving to the dark side has given me a very different thought of what I used to think for 30 years prior to getting to that level. We are in a non-unified state. Or I should say quasi. We have 3 levels of court that are non-unified, but 1 level of court that is unified. I have, I know, wait till I finish this. I have judges that are elected. Some judges at some levels are appointed by the governor and elected for 15-year terms. I have some judges that are appointed by the governor and then approved by the legislature for 10-year terms. I have some judges that run on a yes-no retention. I have elected clerks of the circuit courts, and I have appointed clerks of the district courts. Now, I say all of this to you because it's my job to make all that make sense, to provide an efficient, effective system of justice that shows that we can communicate well with our partners, that we have equity in how we distribute funding. And it has been an eye-opening experience for me over the past 2 years. It's a very different job than what I had before. I love it, love every minute of it, and I hope to make a difference. And I will give that to David.
Good afternoon. My name's David Slayton. I am currently the State Court Administrator in the state of Texas. Been in my current position as State Court Administrator just over 3 years. Previous to that, I was the Trial Court Administrator for 8 years in the smaller, mid-size, I guess, county in West Texas, Lubbock County. I've worked some time in federal court, a couple years in federal court as a manager in Dallas, Texas. And then previous to that was actually, and for any of you doing the some of the game activity, I'm about to give you a hint for one of them. I actually filed documents in the basement of the courthouse when I first started. That's where I got my start. So I feel like I've sort of come through the ranks over time, which has given me, I think, a perspective that helps me in my job today. We'll be talking about this a little bit more as we go throughout the panel, but I definitely think that I have a different perspective on the State Court Administrator than I did before, which is what I hope we can share with you all, some of the things that from looking back and looking forward, kind of how we can work together better. But as far as Texas goes, just about as opposite of David Boyd, who I've always said I want to be like David when I grow up. Obviously, Texas is very large geographically, but we also have what I believe is the largest number of judges in the state judiciary in the country. We have 3,300 judges that are in the judiciary. Those go from municipal court judges all the way up to the Supreme Court justices. We actually have 2 high courts. We have a Supreme Court and a Court of Criminal Appeals because we're Texas, us in Oklahoma. We're very unified, very non-unified. And just to give you an example of that, and I'll probably do this today, so I might as well give you the caveat today. Every judge in Texas is a court. So if there are 6 judges in a certain county, each one of them has their own court number. I know that's very unusual for some of the rest of you from around the country where you have a court with multiple judges. Nope, we have 1 judge, 1 court in our state. So that shows you how independent each one is. And in many of those counties across the state, each judge submits their own budget independently and is funded independently, even though they're in the same county. So funding is primarily local. The only thing that the state funds for the trial courts directly are judges' salaries, and we don't even fund all those judges' salaries, just the general jurisdiction court judges' salaries. And we do some technology funding for those courts as well, but very non-unified state. So my perspective will be different, which is one of the things I think that's really valuable about this panel. Patty?
Thank you. My name is Patty Tobias, and I'm like David Boyd. I've been working in courts longer than David Slayton has been born, and so... Oh dear, yeah, we got the old dogs at the bookend. So they also said I could. They also said I couldn't keep a job. I've had the privilege to work in a number of states, and I'll share with you my perspective. First, I was in, well, not first, second, I was in Missouri from 1980 to 1993 as a division director in the Office of State Court Administrator, and it was during a time when Missouri was moving to state funding of all of its deputy and division clerks, and that was a wild time. It's quite a transition to move from, in a big state like Missouri, to move from county funding to state funding with elected clerks. Then I moved over to St. Louis County, Missouri, the largest jurisdiction in Missouri, during a time of consolidation, and it was not a a happy consolidation, but rather the district judges decided that it was time to remove all of the staffing from the associate circuit judges, and so 13 former divisions were consolidated, and then I came in and they were consolidated under my operations. So then I lived on the other side of the state funding restrictions and structures and policies that were put into place from my previous life. Then I had the opportunity to move over to Idaho as the state court administrator, and I served there for 20 plus years. Before I lost that job and had to come, no. Anyway. And just entirely different state. Idaho is a very unified state, although county funded. We acted in a unified manner to try to implement policies and procedures. Very county funded, elected clerks, and then we moved slowly but surely to state funding of many operations, problem-solving courts, family court services, court assistance offices, technology, and the like. But the administrative director of the courts, along with the presiding judge, would hire the trial court administrators. So together we had that recruitment and hiring process, but then as the court administrator, state court administrator, I delegated the day-to-day responsibility of the management of the judicial district to the administrative district judge and that trial court administrator. But that too gives a different perspective as we talk. So with that, I'll turn it back to you, Laura.
Thank you. So as you can see, the dream team when it comes to experience both in state courts and trial courts. And today we're going to focus on two of the NACM core, the new core principles, leadership and governance. And we left the links in this, and I know you'll have access to this presentation so that you can refer to some of the good language that's in there describing some of the things that are important. We'd like to start with a question, a thought question. So think to yourself, oops, sorry about that. Are you a ship or are you the lighthouse?
Again, this is the USS Montana requesting that you immediately divert your course 15 degrees to the north to avoid a collision. Over.
Please divert your course 15 degrees to the south to avoid collision.
This is Captain Hancock. You will divert your course. Over.
Negative, Captain. I'm not moving anything. Change your course. Over.
Sir, this is the USS Montana, the second largest vessel in the North Atlantic Fleet. You will change course 15 degrees north, or I will be forced to take measures to ensure the safety of this ship. Over.
This is the lighthouse, mate. It's your call. Hello?
What this video is, it's an interesting video. If you were able to follow along a little bit, it shows two people in a control booth, basically communicating back and forth with each other, and one of them says, "Hey, you're headed right for me. I suggest you change course." And the captain of this ship says, "I suggest that this is the USS so and so. I suggest you change course." And so they keep going back and forth, telling each other they should change course. And finally, the person in the lot house informs them that I'm in the lot house. I suggest that you are the one who's about to hit me, and you should change course. Obviously, it's a funny way to talk about communication. And so if Laura will go to the next slide, one of the things we wanted to talk to you all about is how can we as courts, trial court administrators and state court administrators communicate with each other? Because obviously, communication is key, right? We know that in anything we do. But I think whenever we were thinking about this, from both our roles as trial court administrators and as state court administrators, is how can we do a better job of communicating between the two entities and making sure that that communication is solid. So I was tasked with taking on that question, and I think there's a few things that in my short tenure and looking back to my tenure as trial court administrator that I think are really important. The first one, I think, is that we as state court administrators have some responsibility to ensure that, number one, we're communicating outwardly about what's going on at the state court level. So, a couple of things that we've done in our state that is to institute a monthly newsletter, just something as simple as sending out an e-newsletter every month to all of the judicial stakeholders to say, here's the things that are going on. Here are the the grant opportunities at the federal level. Here are the new judges that have been appointed to the bench, and here are new rules that have been issued by the Supreme Court. I mean, it's really interesting. I use the new rules in the Supreme Court as an example because I remember as a trial court administrator, I wouldn't even know that new rules had been issued by the Supreme Court unless I went to the website and happened to go search to see the rules page on the Supreme Court page to see that there were new rules. I see some of you shaking your head. And so, something as simple as us at the state court level doing a better job of just communicating really basic information externally, I think is really critical. The other thing I think that's really important is for us at the state court level to solicit feedback and input. So listen, because obviously I believe that just as many have commented about the beautiful nature of our country, is that innovation many times happens at the local level. I've always said, Texas being as decentralized and non-unified as it is, I think a lot of things that we're doing in our state are really innovative and forward-thinking. And one would think, well, how could that happen in a state that is so fragmented and decentralized? But I think a lot of it is that we have local innovation centers at the local level that are coming up with new and innovative ways of doing things, and then sharing that with the state, across the state, and other entities reinventing that in their jurisdictions. So we've had new ways of delivering indigent defense that have been delivered at the local, that have been created at the local level, and at least in my state, and probably in many of your states, if that were to be an edict from on high to the local courts, it would not be successful. That's just the bottom line. The most recent example of this is we have mandatory e-filing in our state at this point. And when it first went live, we allowed each individual clerk's office to establish the e-filing codes. So the codes that lawyers would be choosing to call documents, because we're a decentralized state and everybody's going to do their own thing. So one county would have 25 e-filing codes and the other one had 500, even if the counties were literally next door to each other. So you can imagine a lawyer's frustration when they're practicing in one court and then the next day practicing in another court, or 5 minutes later in another court, and they have a total different set of codes to use to identify a document. And so rather than just mandating that from on high, we brought together after hearing from the attorneys and clerks who were complaining about that, brought together the local clerks and judges and court administrators and said, let's see if we can work together to come up with a standard set of codes. And crazy enough, we now have in all 254 of our counties a unified set of codes. If we would have tried to do that up front and say this is what you have to do, it would have never worked. So seeking input, I think, is really important from the local level. Now let me turn it over to thinking back to my hat as a trial court administrator and now serving as the state court administrator about what trial court administrators can do to help communicate. The first thing I think is really just having open communication, just generally having that, making an effort to communicate. I know a lot of times when I was a trial court administrator, I felt like there's not a way for me to communicate, and they don't really care what I think. And so I really feel like it's really important for trial court administrators to be sharing issues that are going on at the local level, innovative ideas that are going on at the local level, and basically just providing that information to the state courts. And then, of course, making sure that you're not only just bringing issues to the state court level when you're the trial court administrator, but you're bringing solutions as well. I mean, obviously, you all as trial court administrators know that when an employee brings to you an issue, you want to know, hey, I'm sure you know what the solution is. So another key I would think is making sure that whenever you identify issues, help bring solutions. I mean, as I said earlier, I feel pretty strongly that the trial court administrators and the trial courts are places where innovation can occur and we can try new things. And so chances are you probably have solutions to the issues that we're facing anyway. So I would encourage you to bring those up to the state court level whenever you find them.
Pam was going to add a little bit, if that's okay there. I get the wonderful job being the timekeeper here, so I'm not going to have any friends when I get done with this. Pam, please add to that communication, if you would. Thank you, David. That was great.
David's done a wonderful job in really summarizing, I think, a lot of what we at the state level need you to do as well. When I first came into this job, that was one of the things that we heard from the field, that we weren't doing well. You know, we just weren't communicating enough. And I know that you yourselves have very effective relationships with your bosses, your judges, your managers, your administrators, and it's those effective relationships that make you successful. And I would say that you need to do the same at the state court administrators level, because effective relationships and fair, obviously, relationships will make a difference. And by giving your needs, by knowing what you need and letting the state court administrator know, that will help you. Just being silent or gnashing your teeth about something that you're unhappy with. I was always happy with the state court administrator if they were giving me money, right? I mean, that makes everybody happy. But there are other things that they do, a lot of other things that they do that help you behind the scenes. And, you know, we just need to make sure that we're doing those right things to help you behind the scenes. So that would be all that I would
Great.
add.
Thank you. Let's go to question number 2. Ideally, what should be the relationship between a trial court administrator and state court administrator and state court office? What should that relationship be? Patty, let's start with you.
Well, thank you. I would maintain that all states should practice the state court, trial court relationship that we had in Idaho, or that they still have in Idaho. And I've got 2 Idaho colleagues in here, and they promised me they wouldn't burst my bubble and, say publicly that that was not what we should advocate for. But here's my thinking. As a trial court manager, or as a trial court manager or trial court leader, you're developing the skills and the competencies, or you will be developing those skills and competencies as you take training courses, to establish effective, productive relationships with your presiding judge or your administrative district judge, whatever you call that presiding judge. And that's, to me, the same sort of relationship that you need to develop, and that the state court office and state court administrator need to develop with you. The NACM core competency and governance states it very well, and if I could just read from, maybe I can't read from that for a second. Whoa! The court, from the governance, as you look at your links in there, the court leader should demonstrate competency in the following areas, and one of those is encourage a collaborative, strategic partnership between court management staff and judicial leadership. The ideal leadership between court management and judicial leadership has long been characterized by the court executive team concept, which requires skill in nurturing and fostering clear roles, defined responsibilities, ongoing access to each other, and a shared vision. And then it goes on and provides some additional principles that executive leadership team should embrace. I would maintain that the trial court and the state court need to embrace that same sort of leadership concept and the same sort of principles. The first one would be, to me, that mutual respect and trying to build trust. The trial court administrators in Idaho and similarly in Missouri, those are my colleagues. Those are people that have my back, frankly, and I have their back, and we're a team working together. We're supportive of each other. You know, another key principle to me is to try and promote that ongoing access to one another and that communication that both Pam and David talked about. We tried to do it in Idaho in a lot of different ways. We tried to have monthly phone calls with all of the trial court administrators. I may or may not be able to personally join, but state court administrative staff arranged the calls and facilitated those calls. We had quarterly governance meetings within the state. The governance in Idaho included the trial court managers, and that was an important opportunity for us to carry on. Is that us?
It's flash flood warning.
Oh, okay, good. We're okay.
Flash flood, not tornado.
All right. Another.
We didn't practice.
That was Laura trying to cut me off, doing it in a new and innovative way. We also tried to promote opportunities for the state court office and the state court personnel to be meeting with trial court personnel in their own counties. Whenever I had a Chief Justice come on new, we did a 44-county, 7 judicial district tour. I also made sure to promote that kind of communication and collaboration that as state court administrator, I was in each of those judicial districts at least once a year, some districts far more than that. Another key principle that I think applies not only with that executive team at the trial court level, but with the state court trial court team, is the shared vision. We have to have a vision of where we're going together, not down to how things were going to get implemented perhaps, but that we were going to, for example, implement a system of problem-solving courts throughout the, throughout the state of Idaho, or that we were going to implement a family court program throughout Idaho. Now, of course, there's going to be variations, but we knew we had a shared vision of what we were trying to strategically accomplish. So that shared vision is very important. Another key principle that all of you know from your work as a trial court manager working with judges is you have to have one message. You have to have one voice. If you're going to disagree with your presiding judge, you're going to do it privately. You're going to do it back in chambers, and you're going to say what you need to say, and you're going to disagree. Of course, everybody should disagree, but you're going to do it privately. That's the same, and publicly you're going to, again, tout the message that you've all agreed upon. That's the same sort of communication and relationship that I at least tried to practice and tried to promote in Idaho between the trial court and the state court. If we needed to disagree and fight over something, we needed to do it privately.
Thank you, Patty. I don't hear any laughing from the back, right? No. Smiling.
Okay.
There you
All
go.
right.
David, do you have more to add to that, please?
All right, I think Patty has done a really great job of talking about that relationship building, and I couldn't agree more with her on that, those 4 points that she talked about. I think the key part of really trying to think about it, I always said that I feel like my job as state court administrator is not that different than my job as trial court administrator. It's just the issues I deal with are different. I told someone the other day, and this is definitely not making light of any of my work as trial court administrator or yours, but the issues I dealt with sometimes, sort of the silly issues with, my courtroom is 1 degree too hot, or my courtroom is 1 degree too cold, or I need the walls of my courtroom oiled, or whatever it may be, or a case flow management policy or continuance policy, dealing with those on the trial court level. And then I remember my first day as state court administrator, my first meeting on the job was to go to a meeting where they were informing me that the e-filing contract was being terminated and e-filing was about to go down for the whole state. Just the problems are different, but yet the concepts are the same because you all have those type of issues that you deal with every day as trial court administrators. So just, I think understanding and realizing from a relationship standpoint is that we're dealing with the same things and we're on the same team here, and we ought to be working together to solve those issues collaboratively. I think that's just really important.
I like that, different. And I've heard that, like, you know, the zeros or more, something like that, same concept. Very good. Thank you, David. Let's go to the next question. So how can a state court administrator assure equity in decision making? And if there is a dispute among a trial court administrator and the state court office, which I'm sure there never is, right? No differences at all. What are some effective ways to resolve the differences and yet assure that equity? Pam?
I'm going to start with a little story. 33 years ago, I started in the court system with an elected official who was basically, it was a different time. He would say things to women that we just don't hear anymore. But one of the things that he taught me, and I'm going to change one of these words, was the policy of the 3 Ps. And the policy of the 3 Ps were principle, parking, and politics. There was another P in there, but I'm not going to mention it. But he said, if I learned how to deal with those Ps, that I would be fine throughout my career, because all 3, one's more weighty than the other, obviously, but choose which one, because if you're taking someone's parking place away, principle they might think that that's principle. And recently, I had the opportunity to hear from a bunch of people, staff of 3 courts that are all together, about parking, that there were 25 different parking slots that were assigned to individuals that weren't always there. And then it was overextended, and they wanted those assignments to go away. And I agreed. I thought there's no reason for all those people, those powerful people, to have assigned parking when they weren't there all the time and the others didn't have parking. So I didn't remember back to the 3 Ps of 35 years ago of what that was going to do to the people that we were taking parking away from. But something as small as that, you know, that then also, I know all of you have had parking issues in your careers, and please take the 3 Ps with you and remember that it's always an issue. But seriously, when I came on as a state court administrator, the chief and I went across the state, much like what Patty was saying, and we still do. Every year we try to visit the courts. And the undertone of all the conversations we had in our first year were we were missing communication and there was inequity in how things were run, primarily with money. And it was perceived inequity. And, you know, I had to figure out a way to either figure out if there was inequity or if it was just a perception, and we had to fix it, both, if that was the case. And we did. We looked at our structure. We had the National Center come in and help us restructure. They're a great team when you need some outside help. They come in and they interview everyone. They make a very good presentation. We reorganized our judicial council, our committees. I changed the way we give out grants. I put judges, administrators, and clerks on grant committees from the field. They now determine who's going to get what grants. We revised how grants are given. Give us data, show us the data, make your case, and we'll give you the money if we can. We did all of these things, and I think it's genuinely working, and they all appreciate the ability to, A, take part, and B, to know that it's not easy giving out money. It's not easy making the right decisions to make sure that everybody across the board gets the right amount of money. The problem in a non-unified state is that you have county funding in some counties, and in Maryland, Montgomery County is one of the richest counties in the United States, and then we have one of the poorest counties in the United States. So the perception wasn't necessarily that the state court administrator's office wasn't giving enough money. It was that they just didn't have enough money, because in the richer counties, it's the haves and the have-nots. And the smaller counties, or the less affluent counties, wanted the state to give them more money. And so then, and that's where we're trying to deal with that right now, is how do we effectively generate money from the legislature and then give it out in a way that's fair across the board. And we're coming up with different ideas like security. Every court in the state should have security of one form or the other. We're coming up with a list, and we should fund that. We shouldn't have courts without a magnetometer. We shouldn't have courts without security. So we're looking into bringing our field into the decision-making process, and we hope that that's going to make a better way of governance for Maryland.
Great, thank you, Pam. David?
I'll just add a few comments onto this particular question. Pam's covered a lot quite well. First of all, and this one is really very basic, and that is, treat your state court administrator the same way you treat those that you sometimes might have disagreements with in your office, in the county, or whatever. In other words, you have certain expectations of those people, have certain expectations of the state court administrator, but also understand that the state court administrator is going to have certain expectations of you as well, regardless of what type of system, whether it's unified or it's not unified, state-funded or not. That type of a relationship is really no different. The other, and I have an advantage that Pam doesn't, and that's in Iowa, where we have a centrally funded system, and we don't have, except for the facilities that the counties are still responsible for, we don't have county funding in the system. And so we have formulas, standards that people can rely on. And so my trial court administrators, if they're going to make a business case to me on why they should be treated differently, they know going into it that they're going to have to make a business case based on the standards and the procedures that we have already put in place to be used on a statewide basis. And then you can also use the National Center as a whipping boy, because one of the things one of my jobs every 4 years is to reallocate our part-time magistrate positions in our system. And under my predecessor, they were rarely changed from when they were first allocated back in 1973. So in the early 2000s, when I became the state court administrator, the first time we got to that point in time, I ignored one or two of the P's, and I had Laura and some of her friends from the National Center in who had done a weighted caseload study for me, which included our magistrates, and using that document, I did a major reallocation. Really upset the apple cart, got myself sued, among other things. But in the end, came out with 16 new magistrate positions that I had not asked for from the legislature, as long as I agreed to put them back where I had taken the others away. And of course, I did agree to do that. I didn't say I would do that forever. I just said I would do it that time. And so 4 years later, I went about reallocating again. Anyway,
Great.
Shall we go to
Why don't you
4?
go ahead and move to question number 4, David? As a state court administrator, how do you include trial judges, trial court administrators, and other court managers in decision-making and in the development of state court programs? And we've heard you all say that's a good idea, so how do you do it?
And before I go there, I just want to clarify one point, because some of you are going to leave this room thinking how well this whole thing was planned out. Because if you've been paying attention, you noticed that for the first 2 questions, the primary speaker and the backup were next to each other, and for the 3rd and 4th questions, it's on this side. And the fact of the matter is, this lineup was truly decided alphabetically. So we're not really quite, it's not quite as good as you might think. But first of all, let me say one thing. I'm going to put a plug in, even though, depending on the weather, I won't actually be here to attend myself. But I believe it's tomorrow morning on the schedule. There is a session that talks about, that the title of it has to do with judicial council and the judicial council model. Anytime you have the opportunity to hear Harry Friesen, you ought to take advantage of that, that's for sure. Many states have some kind of a judicial council model that helps in one way or another in the governance of the judicial branch in that state. Some places, like California and Utah, the judicial council is really the administrative decision-making body. In other states, like my state in Iowa, we have a judicial council, but it makes recommendations to our Supreme Court and to the state court administrator, but their decisions are not binding. But we take their recommendations very seriously. But so judicial councils is obviously one way to bridge that gap. But in Iowa, in particular, which I can speak to the most, we basically we developed a culture starting when we moved towards state funding back in 1983. We developed a culture of having everything that we do on the business side of the judicial branch having involvement from the trial courts. And in many cases, some of the committees that we have that deal with a particular subject matter or whatever it might be are actually committees that are put together and are chaired by a trial court judge or a chief judge or a district court administrator in a formal way. But as a state court administrator, I try and do it, and as a former trial court administrator, I think my colleagues initially had some faith in me. They might question that today, but I mean, at the time, I think they had some faith in me. But what I've always tried to do is to make sure that even in just some of the routine business that we do, that I oftentimes will make sure that we have trial court personnel that are involved in the input and developing some of the policies and practices before some administrative directive is going to be signed by this state court administrator anyway. I think it was mentioned earlier, this gets right back into the communication issue and the fact that you need to have open lines of communication between the state and the trial court level. I think that's very important. I meet with, I'm not always there for the whole meeting, but we meet every other month with our trial court administrators. The agendas seem to get longer and longer. But I think that kind of input is really critical. Pam, do you want to add?
I think Patty.
I think Pam's supposed to add, I think. Is it Patty? Okay, go ahead.
I have Patty on mine.
Thank you, David.
Is that right?
A couple of things to add on to David's. How do you include trial judges and trial court managers in your decision making? And again, some kind of governance body is a critical thing. Idaho has a administrative rule governing, who the members are, what sort of responsibilities are theirs. Everything goes still to the Supreme Court. The Supreme Court was never willing to let go of their constitutional and statutory responsibility, but in the 21 years, I can count on one hand the number of recommendations made by all of the trial court managers and that full governance body that did not get approved by the Supreme Court, and they were all related to disqualification of judges. There was just a difference of opinion. But other than that, that body worked very well, and again, that gives the trial judges and the trial court managers the voice they need on budget decisions, on what legislative priorities are. All court rules would go to that. Another key piece is having those court committees that are comprised of trial court managers and trial court administrators and other specialized personnel, bar members, dealing with special topics, again, whether it's family courts or problem-solving courts. No matter what the issue is, we typically had a specialized court committee that worked out the mechanics, worked out the proposed rules, developed and made those recommendations as to budgets, et cetera. The other point that David talked about earlier, that communication, we tried to communicate an opportunity to review any proposed rules, not only when they got passed, when they were effective, but also before. Here are the proposed rules that are going to the Supreme Court on this subject. that you've got an opportunity for 2 weeks to give comment, whatever. So both before and after major decisions, there was always time for input, and we kept things on a weekly basis to try and get news and updates out to the trial court, so that they knew at least once a week they could take a quick look at it. And then finally, another key way to involve the trial court, include the trial court managers and trial court judges. All of the budget, although a lot was county funded, a lot was state funded, and we were able to try and have as many decisions made locally as possible. So on a statewide basis, we would allocate funds to the judicial district, but it was up to the judicial district to make the actual allocation within each of the counties, or however they were going to set up and organize their thinking. So.
Thank you, Patty. Now we're going to ask you, most of you are trial court administrators or in that position or that level, maybe not, maybe you're in the state. But we'd like to turn it back to our, actually, president of COSCA, who in a week and a half we will be meeting with all of COSCA, and perhaps he can take a message for you.
Thank you, Laura. Yes, and we put up, we do have the last question up. COSCA, as I think you know anyway, is a fairly small group. There are only 56 of us in COSCA, counting the 50 states and the territories. And historically, COSCA has been a very stable group. Turnover, really was kind of rare and far between, let's put it that way. And in the last 4 or 5 years or so, over half of COSCA has turned over, which makes the job of our members, Service to Members Committee, fairly critical right now. We're trying to revamp what we're doing and trying to make it relevant to new state court administrators, like to my left, in terms of what COSCA does and how we can help them be good state court administrators. So we decided we wanted to, since we had this opportunity, if I could ask, if there are specific issues that you can identify, and Ms. Tobias down there on the end actually helps staff our Service to New Members Committee. But if there are particular issues that you have identified that it might be helpful for us to take back and work with new state court administrators.
So, comments on that. What would you like these, especially our president here, to take back to our new members? Please.
Is there a mic there? Oh,
I know.
here.
Thanks, David.
Although it's not a specific issue, it's more of a question on mechanics with white papers. How do you look at the, distribution of white papers? Do you routinely do that with your trial court managers? Do you do that with judges? How do you look at that? Because I know they're chock full of information. They're generally very well done, and well, they're always very well done. But I'm interested in knowing what the process is.
Excellent question. Excellent. And good one, since they're policy papers. So you think everybody would want to know those policies, right?
You would think that. And that is a good question. And I think it's one that I'm not sure I really have a really good answer. I mean, we of course do distribute the papers, widely, over the internet. I'm not sure how well qualified I am to speak for 50 state court administrators on what they do with it back in their offices. Patty?
Yeah.
A great question. A couple of things. First, just on a national level, I know that the COSCA white papers are distributed to NACM, and NACM has been adding them to their annual meeting agenda, and that's a great way for folks to get acquainted with them. It is the responsibility of each state court administrator within their state to distribute it, and I know from my experience I used it every year to either analyze what our capacity was, how did we align with it. I always provided it to our governance body, and we either, you know, well, we do all that, or maybe we could improve upon this based upon that white paper. So I always used it for food for thought and analysis and further action. And I know a number of state court administrators. I think it's a wonderful point, though, and I'm so glad you raised it, because I think we should make sure at the new member orientation that we suggest that each state court administrator, when they receive the, you know, we will acquaint the court administrators with the white papers, and they've been produced, and that is on the agenda. But each state court administrator can and should distribute it within their state and bring attention to the issues and use it as a springboard for discussion. I'll include that. Oh, I'm sorry.
Okay.
We're actually, we're recording, so we're trying to catch everyone's comments.
I guess my question also was with the building of the white paper, the research that goes behind it, and how broadly would you distribute it to the group to take some feedback?
That varies, and I'll let someone who's actually drafting the current policy paper speak to that.
Sure. So the process is actually very interesting, and it just has changed in the last year. The way that COSCA writes its white papers. Let me just give you history. COSCA's first white paper was published in 1999. It actually wasn't actually a policy. It's actually called the policy paper. And so what happens is every year COSCA's members choose a topic. That topic is chosen now at the July meeting. So we'll be choosing a new topic in a few weeks. And then someone is assigned, there's a committee, policy committee, who helps make recommendations on that. And then there's someone who's chosen to be the primary author of that. And then it goes through draft after draft after draft. And so right now, COSCA's writing, I'm actually writing a policy paper on problem-solving courts. And it's an update. COSCA's first paper was on problem-solving courts in 1999, and as you know, things have changed a lot since 1999 in problem-solving courts. And so it is interesting, though, because COSCA made a policy decision a number of years ago that the papers would remain somewhat confidential until the end. So it's a very much of an internal discussion that goes on amongst the members. There might be some times where certain individuals are sought out for input on specific things, but for the most part, correct me if I'm wrong to my colleagues, it's pretty much an internal document. The thought there is that sometimes, and if you look back at the past few years in particular, sometimes COSCA's policy papers are somewhat controversial. They've been in past years very controversial to certain groups. And the thought is that we want to maintain the integrity of the process and making sure that we're not changing it just to try to appease some individual group or something like that. Is to really try to think about what do we want to do. So once the paper is processed in draft form, which is where it is now, as of today, it's in pretty much a final draft form. Then COSCA's members, as well as the Chief Justices, are invited to a 3-hour session to actually critique the paper. You can tell how much I'm looking forward to that 3 hours. It's like defending a dissertation, I think. But basically, once that happens, then every member of COSCA and the Chief Justices get to participate in providing feedback on it, and then modifications are made, and ultimately it's adopted at the December mid-year COSCA meeting, and then it's ready for publication. I think it's a really good point about how we distribute it, because there are I can tell you the policy paper, I obviously know it. When it's adopted, we'll have very practical recommendations that each of you should know about. And those of you that have problem-solving courts should be dealing with it. Those of you that deal with limited jurisdiction courts should be taking the limited jurisdiction policy paper that was published last year and seeing how it affects your courts. So, I think it's a good message to take back to COSCA.
Thank you. Thanks very much. We still have 5 minutes. Please. Messages back to COSCA.
So I heard a lot of what it sounds like best practices today with a
Hold it a little closer.
I'm sorry, with an I do this and I would do that. So how do you take your best practices and incorporate them into your learning objectives for your organization?
Great question. How do you take these great ideas you've had as state court administrators from trial court level and get the state courts to do them? I was thinking the same thing. I like that.
I think it's communication. I think I am meeting with the clerks of the court, the administrative clerks, the administrators. We also, and we had to fight this, we put on more clerks and more administrators, more managers to our judicial council. Our previous judicial council was not entirely judges, but there was only one or two lay people, as they like to call us. And we fought and said, we have folks that are running our courts, and we need to hear their voices. We need to hear them, and they need to hear what you're talking, the discussions you're having, so we can all do a better job. I think it gets back to communication with everyone in our education programs, with what we do. We need to. Someone was doing talk the walk, walk the talk, all that. It needs to be done, and I think those of us at the AOC level just can't forget that we are there to support you. That is our job. Our job is to support the courts, and we can't lose that. So we need to communicate that.
So if you're in a state, I just want to clarify. Thank you. That's great, Pam. And before David talks, I'm going to say what I want to know, which is if I'm in a trial court. If I'm a trial court administrator and I'm in a state, and they're not talking to me and they're not including me, how do I get you to do that? And you've been there, so how do you do that?
I was about to answer the question in that way, because I think COSCA, the state court administrators are at a disadvantage to trial court administrators because we don't have a core. The trial court administrators, one of the nice thing is you have a set of core competencies, and of course, obviously, some of those core competencies apply equally to the state court administrators. But there are some specific things that I think that state court administrators need a core. And I know Patty and I have talked about it. And interestingly enough, at the last summer's meeting, the chief justices and the state court administrators and the court management committee, one of the committees, actually had a discussion around when we're hiring new administrators, what should we be looking for and how should we be training them? Because I mean, if you look around, it's different in every state on how this happens and what the chief justices are hiring and Supreme Courts are hiring. And so I think it's something that we really need to figure out from the state court level, especially with such great turnover, which is how to make sure everyone understands sort of what are the core things that you need to be doing as a state court administrator, and how do you make sure the things that we've talked about today are principles that are carried out? I mean, obviously it's going to vary. I mean, we're all going to, four of us up here probably do it differently and to varying degrees of success, but I think it's something if we're able to publish and talk about with our members, it will make us all better.
And I think those points are excellent. What I think, David Boyd, president of COSCA, that's important to take back to them as the new people to understand they need to be inclusive. Excellent. Other comment? We have about 1 minute left. Question, what else can this gang take back to COSCA to make them new and improved state court administrators? Any other things we want to make sure the message goes? Well, thank you very much. We do have as our last slide contact information. So please feel free to talk to, call, email our very approachable state court administrators, even those who came over to the dark side, and join them. And thank you very much for your attention today.